Before we begin today, have you ever wondered about the extensive use of generative AI will result in less incentive for a person to create their own original work or innovation? Or how can a big company show us the most relevant advertisement on our social media platform? Or how easy it is to sell Paris goods online? We should think about those questions because we live in the digital era. So, technology is changing our world and our intellectual property rights are being threatened. Welcome to today's discussion. I'm your first speaker, สุภาพร ฬหาบวรก
I'm the second speaker, ธนิก ตั้งบูรณากิจ Intellectual property law, or IP law in short, is a branch of law relates to establishment and protection of certain intellectual rights.
There are several areas of intellectual property, including copyright, which protect the rights of creators in their own original work.
Trademark, which protect a word phrase, symbols, or design used to identify a product or service.
Patent, which protect new invention. It can be products, processes, and designs.
And finally, trade secret, which protect crucial business information from outsider. Other than these, there are some more intellectual property like geographic indication too.
IP law also extended international protection throughout the globe by various agreements, such as the Berne Convention for Copyright, Madrid Protocol for Trademark, and PCT for Patent.
In the last 1 or 2 decades, we saw a huge leap in computer science field, therefore resulting in more computing power, more storage capacity, and more connectivity. But how does it impact our IP right?
Part 2. AI. More computing powers mean that AI is stronger now. You may heard of ChatGPT. It is a large language model that capable of writing from schoolwork to Taylor Swift-style song lyric. This type of AI has raised a problem about copyright. So, does the output generated from AI is belong to AI or what?
For that question, US authority has suggested that AI cannot be the author of any creative work. However, that doesn't mean that AI generated work is copyrightable. But if somehow it's copyrightable by any means, who is the author of that work? Is it the user that input prompt into it, or it's the AI company that own the AI? That's something to think about.
Yeah, so patent also face a similar problem as copyright. That if the inventive step was made by AI, is this patentable?
And as this AI generated output are based on the past data that were input into it in the process of training it, if the generated work somehow turn out to be similar to someone copyrighted work, is to be considered an infringement, and who is the infringer?
Part 3. Big data.
More storage capacity mean more data can be collected and stored.
Aside from data breaching issue, it's important to address that the data were mass collected and many contain others' intellectual property. This raises questions about data ownership and proper handling to respect IP rights.
Trade secret also play a significant role in confidential information. Trade secret should be kept secret for some reason. But due to the rise of hacking tools and data storage capability, these data can be easier to access, and more adequate measures should be taken to safeguard them.
So, even though this problem is foreshadowed by bigger concerns, it slowly keeps us. Imagine if the data is more accessible, our idea could be stolen even before we could fully create it or register it. Part 4. Online infringement. More connectivity means more ways of distributing unlawful stuff. Nowadays, online shopping platform is a haven for selling pirate goods An illegal online streaming platform is more popular than ever before, so online enforcement is also a big concern.
For now, we have a kind of effective legal mechanism to deal with this. It is the notice and take down. It allows intellectual property right holder to quickly remove infringing online content through a simple notification. Notice and take down is an expeditious and cost-effective enforcement mechanism. It is not perfect. This approach has been criticized for its lack of transparency, accountability, and balance. Another new mechanism that could be supplemented is called blocking injunction. This approach is similar to the notice and take down, but it is a court supervised system, and it also incorporates certain safeguards and measures that currently absent in the notice and take down.
Part 5. Summary and recommendations.
Those are all the problems on future of intellectual property law with the emergence of digital technology. Now, let's get into some recommendations. First, don't be afraid of the AI. Use the AI to the first extent that is allowed by the law, so you can be competitive with others without infringing anyone's work.
Second, don't overlook data privacy matter and make sure to find the best way to protect your data.
Third, capitalize on the easy to access internet to find your infringer and use the provide legal mechanisms such as notice and take down or dynamic blocking injunction to enforce your right. Lastly, I want to say that don't use, don't buy, don't sell, don't support IP infringed product or service. And if you are a creator, quickly realize all of your IP and best protect it.
Okay, thank you for today. It's time for us now. Bye bye.